So if I'm rolling through the hood smoking a blunt, okay, and I've got to have some walking around money on me, right? So I got 25 grand for the ponies and I'm smoking a blunt. I get pulled over for rolling past the stop sign. The cops can just be like, "Hey, I like that money. Let me take it." And
Yeah. They know you're coming from an establishment of ne'er-do-wells, and they say, "Oh, you probably made this gambling, so we're going to take
yeah,
it."
it's the civil asset forfeiture. Welcome to episode 107 of the Weekly Docket, a podcast by the Silberman Law Firm where we talk legal news and practical law. Today is January 30th, 2026. I'm Phil Silberman, owner of the firm and your host, and I'm joined by Chris Hield, who's our supervising attorney. Chris, you have been a little skeptical on AI implementation in law firms, or have you gotten more on board or around to that concept of late?
Man, that's a hard-hitting question. A little bit. I think we talked about this a little bit. I think it's useful. I don't think it's as smart as people thought it was. I'm not really worried about Terminator 2 Judgment Day anymore because I don't think it's as smart as that. Um, but we're learning how to use it and implement it in various ways. It's not a solution to every problem, but it can certainly
Yeah.
help.
I've got a quote here. Do you remember Lock Lord, I believe was a big firm. They merged with the firm and now they're Troutman, Pepper and Locke LLP. I don't know if you've heard of them or not. Um,
I have.
so Will, I don't know if it's Gaius or Gauss, Will Gauss. I don't know how to pronounce his name, but he's some kind of in some type of higher level management over there. And he's what they're doing is they've got a new roles, and a lot of these larger firms they're creating some roles. So they've created an AI partner role for each of its practice groups, right? So I guess if you're in the real estate section or the litigation section, you can be appointed the AI partner for that section. So they've carved out a whole role for. And here's his quote. This is an investment in the next 5 years. Whenever an organization invests in a new technology, puts people hours into a transformational effort, it's making sure that we deliver enough early wins, enough value up front and along the way that the organization has the appetite to see it through all the way to the end. So that's a quote. So, they're at big firms, they're doing this stuff. Now, how effectively, I don't know. Is that just kind of a figurehead, a nod to the idea that we're doing something with AI, or are they getting real results? That we don't know about that. So
Just seems like a quote for exactly what it was. Just, hey, we need a quote. Give us a quote. All right, here it is.
give us a quote, right? I think what Will's saying there is we're doing some stuff with AI, but we're paying attention to the bottom line. We want the stuff to get returns right away. We're not big tech where we're just throwing billions or trillions of dollars at it without any return for hopes in without any kind of results in the here and now. So it's happening. Firms are adopting it, and yeah, with that said, let's talk about, what's on our docket today. Okay. What are we covering that's not AI, because AI seems to be everything that people talk about. So rest of the show, we're not going to talk about AI.
People being no.
All right. So we've got
We talk about AI all day.
right.
So
Yes. A lot of AI goes on over here, but we're going to try to give the AI a rest.
did you see? No, I know I'm throwing you off. Did you see how? And I didn't know this. Every team, like for the NFL teams, they actually make a commercial about their schedule release, which seems kind of crazy. Like, who cares about a schedule release? But the Bills did one, and they call Josh Allen and they say, "Hey, what should we do?" And he says, "Just use AI." And so then they call Allen Iverson, and he's there, and he's like, "I don't know what you guys want me to do, but I'm here." I thought that was
That
hilarious.
is a funny thing, and that
We called him AI back in the
I know, yeah,
90s.
no, Allen Iverson was the original AI. I'm not sure a lot of our listeners are going to pick up on that, so we had to
Yeah.
we had to throw that in there. But no, good stuff. All right, we're going to talk about Texas on our docket today. Texas firm, Texas stuff. Texas is adopting the Uniform Discovery Law. Okay, then we'll talk about what to do when the police take your money when you get that traffic stop. Okay. And then that's also otherwise known as the otherwise known as civil asset forfeiture, I believe. So, and then we have these eviction updates. We missed one. We have to go over notice to vacate requirements. And there's this new requirement. This was one of the tenant friendly benefits that we need to cover. And finally, in our rant and rave section, if I had to change one real estate law, what would it be? This is going to be how to fight bogus contractor liens on homestead properties. So, all right, let's get it kicked off with our legal news section. And this is sort of old news, but it's really been overlooked. Texas adopted the Uniform Interstate Depositions and Discovery Act. Um, that became effective in August of 2025. It's Texas Rule of Civil Procedure 201.3, 201.3. Previously, Chris, you know this, Texas was one of the remaining holdouts to not adopt this act. And what that basically meant is if you wanted to get a subpoena or something served on a Texas resident, if you had an out of state case and you needed a witness in Texas to be served and produce documents and show up at a deposition, then you had to call local counsel like us in Texas. And we had to open up a case in Texas and get the subpoena served. No longer, and it was great for us. It was a little honey hole of revenue, Chris. So we lost all that revenue, but good news for foreign litigants. We've now updated. Are you a fan of this, Chris? No, you no longer are going to need local counsel. You can just wherever you are in the country, you can serve your own subpoena. You don't need a Texas judge anymore. Are you a fan of it?
Yeah, it makes sense, especially since it's been a while since I've had to go out of state, but getting somebody out of state is just way more trouble than it needs to be. Like, if we need information, we need to work together and
Yeah.
allow people to do that. And so it's nice that people can come do it here because we're allowed to do it in other states. So
Yeah.
it makes
I'm a fan of it as well. I mean, despite, my self-serving interest to have other counsel in other states pay us money to open up a case and serve it, it makes sense. I mean, under Rule 201.3, an attorney from another state serving a subpoena doesn't doesn't constitute a Texas appearance. So you're now allowed to do it. Don't have to hire a local attorney. It applies for mostly oral and written depositions is where you see this production of documents. Texas adopted because we're Texas and we do things differently. We adopted a slightly different version of the UIDDA, and the only difference is it specifically excludes premises inspections. Okay. And I guess I get that. Maybe it's Texas dirt, it's sacred. So if you need to come inspect something in Texas, you need to have that blessed by a Texas judge. But that was the one thing we kept to ourselves. So
we do believe Texas land is God's gift to the planet.
for certain, I think there's this song about that, many country songs about that, but we'll forego that. I don't want to have to sing country music right now on the show. All right, let's move on to our legal question section. Chris, you brought this up. I think you had a client that got pulled over. You got him a little bit of money related to a probate, and then he was driving around and got his money taken. You want to just kind of frame the issue for the listeners on this? You remember?
Well, in general, without referring to any specifics, but it may or may not have happened. It's a law that most people don't know about. And as a free market capitalist and someone who doesn't love big government, I absolutely despise this process. But what people don't know is if you are pulled over, or I think, I don't want to go into TSA. TSA has their own rules, so will stay away from that. But any local authority, and usually it's when you're pulled over, you're traveling outside of your home. If you have large amounts of money on you and the police think that you're a criminal, they can just seize your money.
Yeah.
They can simply take your money and say, we believe this came from criminal activity. If you want it back, you get to sue us. You get to, Phil Silberman versus $73,000 in cash is actually the style of the case. And you have to prove that the amount of money that you were riding around town with came from a legit purpose.
Yeah.
And if you prove it, they get to keep your money.
It's crazy. I just learned about this today. Let me break it down for our listeners though, Chris. So if I'm rolling through the hood smoking a blunt, okay, and I've got to have some walking around money on me, right? So I got 25 grand for the ponies and I'm smoking a blunt. I get pulled over for rolling past the stop sign. The cops can just be like, "Hey, I like that money. Let me take it." And
they know you're coming from an establishment of ne'er-do-wells, and they say, "Oh, you probably made this gambling, so we're going to take it."
It's the civil asset forfeiture concept. It's crazy. How does it work? I mean, I was in disbelief, Chris. You're right. United States versus $50,000 in U.S. currency is the way the cases are styled. The police, they don't need to prove that you're guilty beyond a reasonable doubt. It's not a criminal concept. It's a probable cause standard. It's a civil type of action, and they don't even have to charge you, right? I could just, they could just take your money. You don't even have to have charges. I mean, the idea is they just have to maintain that the money was tainted by illegal activity, right? So the smell of my marijuana, tainted the cash. In Texas, this is governed by Chapter 59 of the Texas Code of Criminal Procedure. We've historically had some of the most aggressive forfeiture laws in the country, and under this Texas law, police can take the cash, the vehicles, real estate. They have to have probable cause. Once it happens, there's a 30-day clock that starts ticking. Once the police take your money, you have 30 days for the district attorney has to file a notice of seizure, and then you have to file an answer, and which is, as you know, Chris, legal response, and you've got a deadline, or you could lose the money. And this is the biggest shocker. There's a profit incentive. Texas law allows the police to take up to all of it, 90% of the proceeds for forfeited assets, and which they can use for law enforcement purposes, like buying new Chevrolet Tahoes. So it's like they take your money and they can buy, I don't know, whatever police. I mean, they could go and have a big catering event for the night shift. I don't know, but crazy, absolutely ludicrous. You brought this to my attention. I cannot believe we have something like this in the United States. And it encourages policing for profit. We need some different laws on it. Unless it's like a cartel member that's really up to no good. And then I am for taking his money. Did I mention that? So,
well, but you got to be careful with that, right? That's what everybody always says. Could you represent a guilty person? But what if you know he's guilty?
yeah.
Look, that's not how our system works. So this area just flies in the face of everything we stand for. Everything is, the other way around, innocent until proven guilty. And it's not up to me. It's not up to a judge to say, well, we give due process to everyone except you, because we know you're guilty. Like, we're not going to waste the resources. We saw you do it. We know you're guilty. That's not how the system works. It just isn't.
Yeah. Terrible law. All right, let's move on to our next legal issue question kind of thing. We missed this when we originally did the eviction piece, Chris. there was a change effective January 1st, 2026, kind of overhauled the eviction process in Texas. We're not going to go over it in great detail anymore, but I just noticed that if you're a landlord and you need to send and your tenant doesn't pay rent, normally you don't care whether they were late the first time or the 10th time. You just send a notice to vacate. Breach the lease, notice to vacate, roll into the eviction petition after 3 days. Now it turns out that if your tenant has never been late on rent or it's the first time they're late, you don't get to send them just the regular notice to vacate. You have to send them a notice to vacate that gives them the option to pay rent and then cure the default. We used to call that a notice to pay rent or quit. So that is a very fine, nuanced thing in the law. I raced to the property code and I wanted to see what happens if you don't give them the new notice to vacate after you file an eviction lawsuit after January 1st, 2026, and you just forget, you use your old notice to vacate. It's unspecified what happens, but that tells me that your whole case is probably defective and you've got to go back and do it again. So,
I mean, some of these judges, I may have said this, but it's worth saying again. Some of these judges are so ultra technical, and we're lawyers and we should follow rules, and technical is fine. But some of them will just look at your notice and say, your notice is deficient. Come back when you fix it.
Yep.
They won't tell you what's deficient about it. They just say case dismissed. You can refile when you do your notice right.
Yeah. It's pretty egregious. The more left-leaning justices in JP courts in Texas will, use anything they can to throw you out. So heads up on that. All right, let's get to my favorite part of the show, rant and rave section. I was thinking of today, if I could change any law within our practice areas, what would it be? And this would be the one. All right. We're talking bogus contractor liens. So you have Joe Blow or Chuck in a truck come out to work on your home and the guy screws it up and he decides to file a lien against your homestead for like $1 zillion. There's no automatic process for having that removed, and no less than 10 times a month I have to tell clients, I'm sorry, the cost of being right is very great. The guy absolutely is not entitled to file that kind of lien against your homestead. He doesn't qualify for the lien, but the county clerk's office where it gets filed is just a administrative office. They'll record my son's coloring book if you want them to. And the only way I can fix this problem for you is pay me a $5,000 retainer so I can go have the contractor's lien removed judicially. And the contractor just kind of gets off scot-free. It's a problem. It's one of those things, again, it's self-serving. It helps us as a law firm, Chris. People have to pay us money to fix it, but we have enough work, it seems. I just want people to have a fair shake. It's not fair to homeowners. So,
well, we could make more money on volume if there were a simple process.
Yeah.
So you didn't tell me about this, but so as I'm hearing you talk, I'm thinking about it for the first time. If we had a simple process of, hey, look, okay, the homeowner now disputes it. We either need to have some kind of preliminary hearing, kind of like an injunction, right? If you had something similar to an injunction where the court either agreed to issue the lien until trial or said, no, you don't get a lien, or something that maybe forced the contractor to bring suit. Say, okay, if you are actually owed this money and you want your lien, you need to bring suit. And we're going to have, again, like a TI hearing about that and determine whether you have a probable right of relief on the merits. Stuff like that. So they can't just file a single page and say, haha, now I got you.
All good thoughts. Although I think we have precedent for a simpler process. Okay. And I had the advantage of, thinking about the outline, as I always do. But Chris, look, I'll ask you, don't you think it would be easier just to have this mirror the same concept, the same procedure we use to remove judgment liens and child support liens, where if you're a homestead owner and the lien is technically defective, which it, almost always is, you just file an affidavit saying this is homestead property. it's technically defective. Give the contractor 30 days to rebut, and then if the contractor doesn't rebut, the lien is released, right?
Yeah, these contractors and like the investors, they're pretty stabby though. They're the ones who have figured out how to abuse the law, so they're the ones who figure out how to get around it. But yes, if any impediments we make, any more obstacles we put in their way, is going to be more likely to at least help somebody. It's going to at least help a portion of the people that are being victimized. But
Yeah, and I'm a fan of contractors. I really am. I mean, I want them to get paid for work that they do. And in Texas, we've always prioritized that. But this is the one thing that has gotten out of, I mean, well, there may be more than one thing that have gotten out of control, but this is one thing that is absolutely out of control in the real estate practice. And this does hurt regular homeowners. So I think we could solve this. I might talk to some of my friends that are, in the Texas legislature about getting this kind of bill through to help homeowners. So yeah. All right. That brings yes, they can name the bill after me. They can call it the Phil bill. I've always wanted a bill named after me. So all right, that brings our show to a close. I've been your host, Phil Silverman. Chris Hill has been my co-host today. Like us, follow us, review us wherever you get your podcasts. And as a reminder, nothing in this show is to be considered legal advice, and this has all been for entertainment purposes only. If you have a legal question, email us at info@silblawfirm.com and tell us you want it publicly answered in the podcast. Everybody have a great rest of your week and weekend.